Room, the only way to start your day.
Flag resembles the American flag, but also it is the first country to elect a female president, Ellen Sirleaf Johnson. The country, Liberia, rich in diamond, iron ore, gold, and timber. But the proverb we get from them, the one who climbs a good tree deserves a push. The one who climbs a good tree deserves a push. Ladies, go first. Frida, how would you interpret it?
I think, I don't know, but I think I'm interpreting it in the same way we talk about how we see an iceberg, but never see what's underneath. So in terms of success, once you're already up there, I think you deserve to be kind of not pushed, but supported, because maybe you've gone through so much. Yeah.
Alusala, how would you interpret?
Yeah, I think just like Frida said, I think if someone is climbing a good tree, it means whatever he or she is doing is something good. And I think what the proverb literally means is that the person requires to be supported. Yeah.
Well, so well interpreted, the sentence.
All right. Yeah. So the Business Laws Amendment Bill 2026, let's start off with that and let's understand what exactly is going into this. Who raised it? Where is it now? What does it all contend? Or rather, what does it all bring into contention? Frida, we'll start with you.
Okay, yes. So the Business Amendment Law was actually started in Senate by Chariot. And it was really supposed to kind of shield the big tech. And just to explain that is that a lot of the BPOs or the outsourcing firms in Kenya are not the owners of the job. So a good example would be maybe TikTok would have one of the companies doing content moderation, or Facebook or Meta would have another one in Kenya. So the idea really is to make the BPOs like the people who are responsible, and yet they're not the owners of the work. So then after that, once Chariot put it in Senate, there was a town hall by the president. And what he did is he actually pulled out one of the company and said, "Where are you? We are going to make laws that will protect you. No one is ever going to take you to court." The thing that happened after that is usually when these kind of bills go, they're supposed to have public participation. So as workers or organizing in these sectors, we did send our memorandum, but then we never got like a sitting. And it was also ignored, and it passed, even without considering the memorandum. And so workers then went to court to challenge it because of public participation. But then, yes, again, that was ignored, and now it's with the National Assembly. And at first, they had refused to do any public participation because they said it was already done by the Senate. But recently, they opened it up for public participation, and we were able to send another set of memorandum by yesterday.
Yeah. So when you were in the courts, what was the court's decision or ruling at the time?
Yeah, so I think you could help with that.
Yeah.
Okay, I think at the time this bill was being rushed through the Senate after the presidential pronouncement, we came together, several organizations, from Kenya Union of Gig Workers to Africa Tech Workers Movement to Oversight Lab Africa, and we brought together a team of experts, including lawyers and labor specialists, and we did the memorandum as she has put it, which was ignored. Then with the support of the Oversight Lab Africa, we put up a team of lawyers and went to court. Now, the case was basically challenging the idea of lack of public participation. So the court heard the case, and 3 months ago, the court felt or ruled that because the matter had been taken to the National Assembly, because the bill was originated from the Senate, but after the Senate passed it, it went to the National Assembly. The court felt that the process had not been completed. So it felt that it was like premature to make a ruling on it. So it directed that we wait and see the National Assembly proceedings and see how it goes. If we feel the public participation has not been adequately done, we can still go back. So the ruling was our petition was a bit premature because the court felt the process had not been completed at the National Assembly.
The originator of the bill is Aaron Cheriot, who's the senator. So
Senate
that means
leader.
the bill began at the Senate.
Yes.
And even at the Senate sittings, public participation is mandatory.
Yes.
That's what I'm hearing from you.
Yes.
Right? Yeah. That even now, even if the matter is at the National Assembly, still there is an aspect of public participation at the Senate that was ignored. That is the bond of contention. But what one asks the question, with protecting the big tech firms, what exactly do we mean? You know, because Kenyans want to understand when you say the bill seeks to protect the big tech, what exactly does that mean?
Now, you know, first of all, if you go through the bill, they are, you know, they normally say the is it the secret is in the details or something?
The devil is in the details.
Yes, the devil is in the details. There was a specific clause in that bill which was saying that, for example, Meta does not hire people in Kenya directly. It does through, by then it was doing through a company called Samasos. Now, what that means is that what the bill was trying to say is that, for example, if I'm a Kenyan who has been hired by Sama, but working on Facebook content, and I feel that my rights have been infringed on by Facebook, who is actually the person I have a contract with, but I've been hired through the BPO. I could not sue the mother company who has a contract with me. Now, what that does is that the workers were being exposed because, on one hand, you have a contract with the parent company. But on the other hand, the bill is saying you cannot sue the mother company that has given you the work. You can only sue the BPO. And yet the BPO says, we have no contract with you. I was just an agent to hire you. So the bill was literally protecting the real owner of the job, the real bearer of the contract, from any prosecution in Kenya. That is basically what the bill was trying to do. Yeah.
Okay, when you say that, it's kind of like a blanket thing. So that if you acted in any manner that was contrary to, number one, the law, labor laws, because you don't hire anybody here, but your practice, anything attached to your practice, essentially you're immune to the laws of Kenya.
Right.
Yes.
That's serious, though.
It
And
is.
actually, even at that time, I remember there were these workers who had been hired by Samasos, who had actually very serious problems with the company. And they had actually even moved to court. Do you know, surprisingly, 3 years down the line to date, the case has never taken off.
What does that mean?
Reason being, the company has always been raising preliminary objections on matters of jurisdiction, saying they cannot be sued in Kenya because they are not a Kenyan company.
Okay. Senate is parliament.
Yes.
Okay? They are part of the legislature, which is an arm of government, which is meant to make the law, oversight, budget, and such. Why would Senate be involved in making a law that seems to go against everything constitutional and then want to stand by it, Frida?
Yes.
Unless I'm not understanding correctly what has happened here.
Yeah. Okay. So first of all, maybe if we look at the bigger picture, there's this bit of unemployment in Kenya for the youth. And one of the spaces that government feels would be able to kind of fill that gap is the BPO, or the outsourcing firms. And so this bill is supposed to kind of help the BPOs or the companies themselves to have an enabling environment in this country. There are three things that we are, because once you have laws, everyone, especially the outsourcing companies and the big tech, are very good at looking at loopholes, right? And so when we say that the first one, which is clause 10, is we need to know who is the boss. Currently, they have put the BPOs to be the employers. But then we know that the BPOs also sometimes give contracts that are 3 months long, you know, and in the name of fixed term, because these BPO workers are not yet classified as employees. So they still are not getting the benefits that they require in terms of being, the employer-employee relationship. Then the second thing is also around, I'm talking about, first of all, who is the boss? Then what is the duties of this boss? Because they are leaving out other people. They are talking about BPOs and information technology enabled services, which brings in all the platform workers, right? And so we need to say that if you're changing the definition of an employer, it needs to work along exactly what the employers do. Employers decide rates, right? Employers supervise you, but in this context, we are supervised by algorithms, right? So that should also be part of definition of an employer, where if the algorithm decides what you get paid, when you get work and all that, it's direct, indirect control, right? And so that should also be part of it. So what we are saying is that as much as it looks like it's a good bill, it's not thinking about the labor rights. Yeah. It's not thinking about the workers who are supposed now to be growing or be part of the growth of this national BPO, or rather the outsourcing firms. So there's also the bit of occupational hazard.
Yes.
Where they say that now they recognize that any place can be a workplace. My home, if I'm a freelancer, maybe the car, if you're an Uber driver. But then it's not clear then who is responsible to pay for any kind of health hazards you may get when you're in the house. If I work on a platform like Upwork, who is supposed to be taking care of this? Is this the client or is it the platform? Uber the same. Even the BPOs themselves, some of them have people working remotely. So who is supposed to kind of compensate for that? So those things are not very clear. And if we leave it the way they are, it's going to bring a lot of loopholes. Yeah.
Alutalala, some of the concerns as well that have been raised, because I remember when the matter was being discussed heavily in the country, especially with the outsourced company, was the issues as well to do with workers' mental health based off what it is they saw in the back end when they were training the AI system within Meta. Yeah. And with that, several testimonials came out because people didn't know where to run to. That is not covered there. Yeah. They do not have insurance and all that. But here now we're looking at labor laws in the country, because based off what I understand is the contract is between you and the big tech, not between you and the outsourced company. Yes. But while pushing that, then one asks the question, even as we push for that, is there a way where gig tech-savvy Kenyans are protected by the law as we stand today? Or is it just an open field where anyone can come in and play?
Now, okay, actually, before I come to your question, let me just weigh in on Madam's question about why would Senate come up with a law that seems to be protecting big tech at the expense of the Kenyan workers. Now, one thing we need to realize is that because of the huge youth population that is unemployed, government is very keen on creating jobs, which is a good thing. But the problem that we have as a country is that we are very good adopters to technology and opportunities, but we are very poor at coming up with the regulations to protect our people. That's why, like 5 months ago, you heard about this case about Uber exiting the Tanzanian market. Yeah. Why Uber left Tanzania was that the Tanzanian government is very intentional on protecting their workers, their citizens. That's why they have come up with standards to say if a company is working in this country, these are the minimum standards that we must meet in terms of labor protections. But what happens in our country is that anytime government tries to come up with a regulation, it is always for the investors. Okay. It has nothing to do with the workers. It has nothing to do with the labor component. Now, to your question, today, the 5 labor laws in this country, none of them is tech ready. None of the labor laws in the country today talk about platform work. None of them talks about the new forms of work that are currently now the in thing. Some of the labor laws are not even consistent with our 2010 constitution.
How can that be?
It is.
When the government has been very keen, at least in the last 2.5 years, to talk about job employment and job creation on a platform that the government itself has also created, where these jobs are then on that platform. Yeah. What is it called? Ajira
program.
The program whereby you can now log on and find some of these jobs, some of the platforms that you mentioned are on that platform.
Yes.
Why would it be that of the 5 labor laws, none of them are providing any kind of protection or legality within tech when the very platform established by government is 100% tech-based?
That tells you the issue of regulation and where the focus of government is. Government is focused on creating jobs, which is a good thing, but it has zero focus on what type of jobs are being created and the impact of those jobs on the young people that we are entering into this market. Just a few months ago, a member of our organization actually left the organization because of mental issues. You talk to some of these young people doing these tech jobs, the content moderators, the data labelers, you hear their stories. These guys are going through mental depression. But
as a result
laws,
of what?
As a result of the work they are doing.
Okay.
You know, when you talk about content moderation, it literally means that when you post something on Facebook or on TikTok,
right,
before it comes onto your phone, there are people working in the background to clean that,
or to ensure that
what comes onto your screen is good content.
Okay.
So that means these are the people who are experiencing all forms of content firsthand, including very hazardous content. Now, if you read our Occupational Safety and Health Act, which is meant to protect workers from harm at work, it has nothing to do with platform work. It has no protection whatsoever for people who are doing such type of jobs. It is as old as, is it 1957? When was the act passed?
The employment.
The OSH.
Yeah.
It is very old. Even the Employment Act, it is of 2007. Our constitution is 2010. So the 5 sets of labor laws have nothing to do with the current forms of work. And that is where our problem begins.
And you see, at the end of the day then, because if you look at platform work, especially those who are moderating content, there is the end consumer.
Yes.
Where am I headed with this? Because if I see something on these platforms, right, that injure me, that hurt me, I will sue. You get what I mean? And by the time I'm suing, if it's Kenya, because we're using the algorithm that is Kenya and also the internet provider is Kenya, right? I will sue perhaps then, if I sue Meta, does it mean I sue Samasos or I sue the person who was moderating the content? Because it is not clear. I'm going to give you an example. The other day I was talking to an individual because of the DSA Act that is in Europe. And there was an ad on Meta platform. And what happened is they looked at it, it was mis and disinformation. They reported to Meta what happened. 2 days. It was brought down and even the website was brought down. The ad disappeared. In Kenya, if I am injured by something that is on these platforms, who do I sue? Do I sue the gig worker? Do I sue the BPO? Do I sue the parent company? It is not clear.
Yeah, that is not clear. And I think to bring that home, you remember there's a time the country was talking about X and the misinformation there. And one of the things that came out from the Haji is that as much as they as the intelligence team in Kenya, would go to Facebook to either say there's misinformation here, they take forever to respond because there's no clear pathway. You'll just do tickets. And tickets are also automated. It's not the same if someone was doing the same reporting if they're in America or Europe, right? So that is why they were also wondering as a country how best to deal with this misinformation on X, because they also, being the intelligent team, can still not sue or get in very good information from Meta. So that is also very unclear in terms of who can you sue. And that is why they get away with all these things.
But Frida, do we have terms and conditions in terms of operationalizations of all these big tech in the country? Because at the end of the day, it is not Kenyan born. It comes from outside.
Yeah.
They're registered there. But there are terms and conditions with which then guide a society or a country that is Kenya. Do we have those laid out clearly so that if someone is operating in Kenya, they know these are the set rules, this is how we protect our citizens, this is how we protect the labor community that is helping with moderation of the same? Or is it just an open field?
No, it's an open field currently because we don't have that kind of regulation. Actually, one of the things that looks like and it's a very good thing, is that now the fight had to go global. We had to have the International Labour Organization coming, bringing the platforms and the workers and governments this June. But this has been something that has been discussed for, I think, since 2023 or before. And this is because they have identified that all these problems we keep talking about, whether it's the deactivation, and deactivation is just a rosy word of you're fired, whether it's the fixed terms, whether it's a content, the harmful psychosocial harms, it's global because this platform operates in Europe, they're in Kenya. So this has now allowed the International Labour Organization to pass a convention. But then this convention requires our country, Kenya, to ratify it. And when they ratify it, then we have to put laws in place, meaning we are about 10 or 15 years behind from since the platform started coming to Kenya and hiring people.
Okay, so in terms of recourse, I guess that's the next conversation that we will be having, because then what happens next? And let's just go a little bit into what this actually means. I've seen some comments here where people who might be engaged on these platforms are talking about the fact that they don't have any kind of protection. They're just basically doing a job, getting money, no insurance, no clause whereby there's a recall, protect, nothing like that. And so again, I go back to how then do we allow, or how does the lawmaking body allow such a law to pass? Okay, we're talking this morning with Wycliffe and Frida, trying to understand this a little bit more, and then also to find out where this, in terms of process, where this bill is, and if it's likely to go through. Amendment to it, rather. Okay, so we'll come back and continue with that conversation. We'll take a quick break and we're back. This is a Situation Room. Good morning.
The bill to us has no input whatsoever from the people who really do this work. And that is where our problems begin, because whenever government wants to come up with a regulation, they are keen on looking at the investment bit, but they don't look at the people who are going to do this work. Okay. So our focus here is that we have special focus on 3 clauses in that bill, clause 10, 11, and 12. Why we are keen on this is because we want this term employment to be defined in the sense of platform work. Who is an employer? Who is an employee? What is the relationship? Because like my friend asks here, if today you are working on a platform and you get injured,
yes,
you have no person you can sue, because you are not going to sue the mother company, because it will tell you we are not local operating, I'm physically present in your country. You are not going to sue the BPO because they are telling you I don't have a contract with you, so you are not my employee. So you are left in between. So we want this clause 10 to be reviewed to define any application that hires people through their online. Even the agents, that means the BPOs, to be classified as employers. The reason why we want this done is because, for example, myself, I'm from the ride-hailing sector. I've been driving Uber for the last 10 years. Actually, this is the 11th year. Uber calls me an independent contractor.
Okay.
For the 11 years I've worked with Uber, I don't have social protection. NSF Uber doesn't pay for me NSSF. I don't have NHIF or SHA, the current SHA. What happens when I drive on this Uber for the next 10 years? Where is my social protection in old age? Now today, government tells us we have like 1.2 million young people working on platforms. Meaning all these 1.2 million people And most of them, by the way, the people who are working on these platforms are basically high school graduates and university graduates, very fresh from college. So if these young people are joining this work and they are going to do this work for the rest of their lives without social protection, what society are we building? Number two, what is the mental health of these people? Are we creating jobs that in the next 5 to 10 years is going to produce 1.2 million zombies in Kenya? Because if our young people are being exposed to this content that is actually harming their mental well-being, then we are building a society of mentally ill people. So we must ensure that platform work is work, the way it has been defined in the ILO convention, and we must ensure that these people are protected. That is our focus.
And as you add on that, then one would ask the question, say, if today we're talking about, say, Uber or Meta at home, where they're registered, say, in America, what are we seeing those in those spaces getting in terms of social protection, in terms of being protected legally by the rights and everything else, for us to then draw comparisons and say, either we're getting short hand of the stick because perhaps they are hiding under where it is they've been registered.
Yeah. So in different jurisdiction, there are people who have been able to kind of go some miles with the platforms. A very recent one was in Canada, where the riders, the Uber drivers, got into a union. And they actually didn't even get to a union of their own. They joined a food union. But it's because they understood the power that comes with being a union. They have had now something that has never happened before, a collective bargaining agreement with Uber. And they have very clear benefits to the point of social protection, bonuses if you've worked in Uber for maybe 5 years. They've also talked about pay rise, how it's going to be happening over time. So there's that shows us that if we organize, because that's one of the other things that has allowed us not to be heard, is because of not organizing and amplifying our voices as it should be. So when a bill is being discussed, or maybe a policy, we are not on the table. And so what will happen is that the people who are on this table are the ones who are going to decide that. The second thing would be Europe. Europe has also done a lot because they have gone as far as having an AI Act. And for the people who work on platforms, whether they're in freelancing, for example, Italy, what they have done is that because they have been suing and going to court on this, now they have brought all these lawsuits that they won, and they have told their courts, this is deliberate for these platforms, right? So what the courts have ordered is that someone is actually sitting with a Glovos to see how their algorithms work, so that they can confirm that this is very intentional in terms of how they exploit us. It's not business. It's not technology. That's not the excuse. India has also done the same, and Spain with riders. So there are countries that courts have listened. There are countries that their legislation has worked. And because our argument is because this is the same platform, for example, Uber, if they are able to do this in other countries, why are they not doing this in this country? It remains to be, it's our government that's not regulating or it's not hearing the voices of the workers.
But do they operate the same way in these other countries, whereby there is eternal moratorium on social protection, for example, for these companies? Do they operate the same way in Canada that they do in Kenya, whereby they cannot be sued, for example, in terms of the need for worker compensation? Do they?
So they used to. Because usually what they have done is that they have their mother company in Netherlands.
Yes.
And when they began, if any other country would try to sue them, you'd be asked to go to Netherlands. But because of the agitation from the workers and also some governments, and for example, here in Kenya, they have an office. They're supposed to be operating under Kenyan law, regardless of the fact that they say they are in Netherlands, because that was passed as a regulation. So yes, they have operated the same, but because of the different agitation, the exploitation coming out, different governments and different courts have taken different pathways in terms of making sure that the workers are protected.
Okay. So what you're saying is that there is a way, because what we try to do is point ourselves in the way of a solution to this. And am I hearing, Wycliffe Frida's talked about if people were to come together, because this united action then would lead or make the person that you're trying to get into the conversation then bend. Because it's not a question about whether people want the jobs. The people want the jobs. People are doing the jobs. Governments have created the jobs, or created the environment through then those jobs can be created. So on whom then? I mean, sure, Parliament has a role to play here, but then also the folks who've activated the jobs, the folks who are working on them, the people who came together in Canada, the example that she gave were the people who were in the system. What needs to be done here? Because we've heard these complaints for a very long time. What needs to be done here?
Okay. What needs to be done here is what we are actually doing now.
Okay.
Talking about these issues, mobilizing the workers, because that is what actually the union is doing. That's what we are doing through Africa Tech Workers Movement, and ensuring that the workers' voices are on the table. Because as I said, many times whenever government is coming up with a regulation, the workers' voices is not there. So what needs to happen is that we need to amplify this sound so that every worker knows that there is something happening and it is important that we speak out. Because, for example, one of the things that has always been a stumbling block to these voices coming out is that the way platform work is done is that everyone does it. Like, for example, in Uber. When Uber came, we were told, you are your own boss. You are an independent contractor. So you buy your car and your phone, you download the app, you start working. So there was no need of engaging anyone because you are your own boss. But over time, we came to realize that this illusion that we were independent contractors was just a hoax. Because you can't be an independent contractor who has no control over your work, you have no control over your income, you have no control over the decisions that control your work. That is not independence. And that's why in this particular Senate bill, we are actually proposing that there should be a third category of categorization of these workers called the dependent contractor. Because there is a lot of semblance of employment relationships in this work, and there is also a semblance of some independence, given the way the work is done. But also, there is a lot of control, meaning this is work that people have become dependent on the applications. So we are proposing the creation of a third category called the dependent contractor. So we have the employee relationship, we have the independent contractor, and we have a dependent contractor. All should be included in this bill. Because what that seeks to do is to bring out the issue of misclassification. Because what misclassification has done is that when you are labeled an independent contractor, it ensures that you cannot have any rights as any other worker. Because it's like you are just someone who came, you are given some piecework to do, you have no relationship. So that is what we are trying to cure.
If I may add to that. So there's also another thing I wanted to add in terms of active participation for the workers themselves. Because if you look at also the way unions are, for example, if I may use the example of teachers, when you are hired by the TSC, you automatically get into a union and your dues are sent to the union. For platform workers, it has to be very intentional and we have to highly participate because there's no one that's paying this money for you or telling you you have to get into this union. Why I'm saying this is because we need to demonstrate what is happening, right, with evidence. So, for example, the other day we did a survey for drivers in terms of how they are deactivated and what it means and the impact in their lives. But then realized that this deactivation is across all sectors of the platform work. And so if we don't bring that out clearly and say, stop calling it deactivation, this is firing. If it's on the BPO side, stop giving people fixed-term contracts. Because what they do is that they will not fire you, but they will wait for your contract to end and then say that's it. if you look at the way the Employment Act is, they cannot just, I mean, here, you cannot just be fired in the morning. But with the BPOs, and this is a very recent example from a company called Nakama, where you get trained, you have your probation, and then you're just when you're about to transition now to the real work, you're told you have 2 days. They give you a letter, your work is done, 2 days to get out of there. So that's not protection, right? And that is what we are saying, that it might look different in different sectors. Even the content creators, they also are. I mean, one day you have very good ratings, tomorrow none, and there's no explanation. So there's need for all platform workers. And when Wycliffe said about 1.2 million, I mean, let's build power ourselves so that we're able to demonstrate and expose these things, and also be on that table so that when we are talking about investment, we are making sure that labor, you cannot create jobs when you're not thinking about your people.
I mean, it is important for governments to continue creating job opportunities, right?
Yes,
it is good that we're inviting investors into the country. But one asks the question, what are our terms and conditions? We've just said that does not exist as we speak at the moment. And one then asks the question, the originator of the bill, Aaron Cheruiyot, did he understand what exactly he is pushing? You know, because if you look at the nitty-gritties of the bill is the BPOs have not been protected. The end user is not protected in this. The only person here who is enjoying everything is the mother company, who in one way or the other are saying, we are not involved in this process whenever someone complains about it. And if you hear the president as well say, Wewe Amuka, we will protect you so that you can come invest. Is government thinking about the nitty-gritties and protection of mwananchi when it comes to these jobs that everybody says is going to come? And how do we push them then towards thinking the way we are all doing so in this house? Because if someone in US is being protected, someone in Canada is being protected, yet Uber Kenya, if you go to US, it's the same thing. Why are we not seeing that apply here in Kenya?
Now, the funny part of this story is that whenever government is coming up with a bill, for example, we had the BPO Act that was being passed. Do you know, during the public participation of that bill, workers were never invited. But when we saw it in the papers, we had to storm the session. And guess who had been invited? All the BPO companies. Their CEOs were in that thing. And if you were to read the act as it were then, it was actually just the service level agreements of those companies that was being made to be a government bill. Yani, it was just like taking the Uber service level agreement and making it now the BPO bill for Kenya. So these things have happened. Even currently, we are having the AI bill. The way that thing is being done, the workers are nowhere. These guys just take the service level agreements of those companies, or what they call the terms and conditions for those companies. They come and make them look like it is now the proposed bill that is going to govern the sector. Meaning, it's like taking the employment letter of the Standard Group and making it now the official media bill that will govern the media industry in Kenya.
Okay.
That's what is happening. So, for us, we are very intentional, and we are really working together with several organizations. Now, like the union, like what she has just talked about, the issue of deactivation. One of the things that we are doing through this bill is that we are trying to name use the words that have been actually brought in by these applications into real labor terms. Because these companies have some very good words. For example, deactivation is a very nice word if you listen to it. But deactivation is literally either being suspended from work or being terminated in labor language. So we are looking at this thing and asking ourselves, what is deactivation and what is its impact? Now, the survey that she's talking about, it had very serious findings. For example, we surveyed 269 drivers in Nairobi, Mombasa, Nakuru, Kiambu, and Kisumu. all these 269 drivers, the report said that 93% of those drivers rely on these applications as a full-time job. Number two, 74% of those drivers had active car loans. Number three, 63% of those drivers were never given notice before the activation. So what does that tell you? This is someone who has bought a car. He has gone to Uber on the promise that there is work and he can be able to pay for that car. Then one day he wakes up in the morning, the app is off. What do banks do? They come for the car. What does it mean to the life of that person? Because this is his main job, no livelihood. So some of these terms that are being brought here by the applications are very dangerous when you look at them from a labor perspective. So what we want to do is that we want to ensure that this bill must be interpreted from a labor context, not just the semantics of the apps.
But do we realize that the reason why the semantics are being used obviously is because these companies don't want to be under the responsibility of the labor laws of the country. I mean,
they are avoiding accountability.
Right. It's clear what the intention is. Yes. So if you know that somebody's come to if somebody's come to brought a gun to a knife fight, here it's obvious that they're going to be faster at it. So from the very get-go, it's been established that, okay, so we're going to come in, we're going to make our profits, we're going to provide jobs at whatever level, but you're not going to be able to hold us accountable for anything. It was in the DNA of their agreement.
Yes.
So how do you start to remove that when you've been 11 years on a platform, other people have been doing Upwork work, that's all they know. They hold up in their houses from morning till night, crunching the numbers, doing the thing. They've been doing it for years because it provides something that's better than nothing.
Yes.
Right? However, it looks as though these folks are getting away with murder. So how do you undo the DNA? It was embedded from the very beginning. How do you do that?
I would say first and foremost,